49,000 employers have applied for that. It's a figure that blows my mind, to be perfectly honest, because I think some of those employers will run into difficulties later on in the year. But there are 337,000 people benefiting under that scheme. So in large part, it's a very positive one. And then we have 205,000 people are availing of regular job seekers benefits. So the total number of people, depending on the state at the moment, is astronomical. Because of the speed with which the entire COVID-19 pandemic developed, the government had to act quickly and had to introduce legislation and regulations that have not been thought through to the same degree as regular legislation or regulations would be, and that will give rise to problems. Some of those problems are starting to become visible now. Others are predictable in terms of their impact later in the year, and we'll see one or two of those potential problems being highlighted a little later in the presentation this morning. But the 5th of May deadline is approaching, and lots of people are asking, well, look, what's going to happen when we start to open up again? I suppose the first thing that I should say in relation to that 5th of May deadline is that we shouldn't assume that everything's going to go back to normality or anything approaching normality when we get to the 5th of May. I know that I've been preparing for reopening and getting people back to work, but I don't really expect that it will actually happen immediately. There's going to be a return on a phased basis. One point to note is that the pandemic unemployment payments, the 350 payments, run for 10 weeks from the 24th of March. Now that indicates that the government was thinking at that point in time that we were effectively going to be in difficulties for about 2.5 months. We're only a month into the period of time for which they were providing. So there is, I think, an expectation on the part of government that there will be a lot of people who are still out of work as a result of COVID-19 heading into May and even June. So whilst it's a good idea to prepare for a return, I wouldn't assume that everybody will automatically be returning. The questions that I want to answer today, and we'll probably answer half a dozen others in the process, are number one, we're planning to return to work. What do we need to do? Number two, an employee doesn't want to return. What do we do? Now, we've had lots of questions around that particular issue where people are sitting at home getting their €350 a week and perfectly happy with that situation. So we'll address that and some of the different scenarios that can arise or that are arising and that are resulting in people being reluctant to return to work. The third question that we want to address and answer this morning is, can we expect or require everyone to return on the 5th of May? The fourth question is, can employees demand redundancy payments if we don't bring them back immediately? And the short answer to that question will be straightforward, but there are some other issues that arise in relation to potential redundancies down the line for some of you, hopefully not for too many of you. And the fifth question then is, does absence on layoff or the pandemic unemployment benefit constitute a break in service? There was a couple of very interesting questions came into the chamber around that particular issue. So we'll need to deal with them. Fiona, you might take us to the next slide there, please, if you don't mind, and we'll tackle that first question. Now, at any point as we work through the presentation, I'm going to be more than happy to deal with people who want to interject and throw questions at me, because you'll fall asleep if you're listening to me for half an hour without any interruption. So feel free, if you need clarification or you don't understand something that I'm saying, to jump in, just not all at once. So the first question that we wanted to answer this morning is around this idea of planning for return to work and what needs to be done. Well, I suppose the first thing to say on that particular question is that it's much easier for the country to shut down than it is for it to open up, and it's easier for the government to provide for shutting down than opening up. And it's more problematic for employers from an employment law perspective, at least, to reopen, because there are a number of general legal obligations or duties that are imposed by existing legislation on employers that may cause problems at this particular time. Now, Margaret is asking if anyone's having difficulty hearing me. Is my sound poor? Fiona, can you hear me?
I can hear you perfectly, Adrian. I'm interested to hear from others. Somebody else raised their hand there. S. Byrne. Jo says she can hear perfectly. Lots of people, no hearing issues. So I think it could be an issue from Margaret. Sad to say it.
Okay, all right, good.
Thank you though, Margaret, for letting us know that.
Yeah, do please let us know if there are problems, because we don't want you to be wasting your time.
No, thank you.
So, thanks. So the first general legal obligation that that causes some concern, in particular at this point in time, arises under the Safety, Health and Welfare at Work Act of 2005. And that act provides that every employer shall ensure, so far as is reasonably practicable, the safety, health and welfare of their employees at work. And that the Act then drills down into particular aspects of ensuring health and safety. So you have to ensure that people have a safe place of work, a safe system of work, competent fellow employees, etc., etc. And in the normal course of events, there's quite a bit of work to be done in ensuring that we provide a safe place of work, safe system of work, etc., for our employees. But at the moment, if you're operating a retail outlet, for example, or you're operating a restaurant or a pub or an office that's open to the public, it's extremely difficult to ensure that you're going to have a safe workplace for people to attend. And there's a potential, or a real potential, I think, for a flood of personal injury cases at a later stage arising out of this COVID-19 pandemic. It's interesting watching the news from other countries like America at the moment, where, as you know, President Trump is, on the one hand, saying that there are certain tests that states have to pass before they can allow businesses to reopen, but on the other hand, seems to be encouraging businesses to reopen. Imagine a situation where our government on the 5th of May says you can reopen and we all return to work, and your premises or business reopens, and a number of your staff contract COVID-19 as a result of dealing with members of the public, and that causes, please God, this won't happen. This causes a number of them to end up in hospital for a period of weeks, or potentially even more significant consequences. Is it a situation where you're then liable for having reopened your business too early, or for not providing sufficient or adequate personal protective equipment? At this point, I don't think people want to articulate that possibility, but I think by the end of the year, we'll be seeing a flood of claims in the civil courts as a result of businesses having opened up too early, employees having contracted COVID-19 and having either suffered significant injuries themselves or having passed the virus on to their family and friends. And contact tracing, which we're expecting to see happen in a fairly serious way when the economy reopens, that contact tracing is actually going to make it easier for personal injuries lawyers to prove those claims. So that is a significant concern. And against that backdrop, Fiona, you might take us to the next slide, please. Against that backdrop, it's going to be essential that anyone who's looking at reopening their business takes a number of steps in order to minimize the risk of, number one, employees contracting COVID-19, and number two, themselves being exposed to claims later in the year. Now, the steps will vary from business to business depending on what type of business you're engaged in, but it's going to be vitally important that we follow Government and Department of Health or HSE guidelines, particularly in relation to social distancing. If there's evidence that you haven't followed those guidelines, that you haven't been ensuring social distancing in your workplace, and employees contract COVID-19, then they are going to be able to sue you, and they'll have a very easy time in succeeding with those claims. I know I sound like the Grim reaper here when I talk about the risk of claims arising out of this current scenario. And I don't want to do that, but I think it's a distinct reality. I know that it's going to happen, and I don't want to see Wexford businesses in particular being hit with those types of claims. The second point I have on the screen is in relation to following guidelines produced by the Health and Safety Authority. Now, I've put the words "if produced" after that bullet point because those guidelines do not appear to exist at the moment, but I'm expecting that the Health and Safety Authority will be producing guidelines in the short term. So it's worth keeping an eye on their website, and if and when the guidelines are produced, make sure you familiarize yourselves with them and follow them in your workplaces religiously. The third bullet point there relates to industry guidelines. A client directed me last week towards a copy of guidelines that the Construction Industry Federation had produced. And those guidelines are excellent and available, I think, from their website. And if anybody has difficulty in getting hold of them, please feel free to email me and I'll pass on a copy of those guidelines. But they go into considerable detail in terms of steps that construction companies can take when they reopen in terms of ensuring the health and safety of their employees. And in construction, I think sometimes it's going to be easier, funnily enough, to ensure that you're following safe work practices because at least people are going to be out in the open and social distancing might be a little easier. I think it's going to be harder in large open plan offices where you have a significant number of employees sitting quite closely together. Some clients of mine who are already operating are operating on a split shift basis in those office environments where half of the people come in from 9 a.m. to 1 p.m. The other half of the staff come in the afternoon, or they're working every second day, just so that they can ensure that social distancing guidelines are complied with. Fourth point on the slide is in relation to following the advice of occupational health doctors. And I think if you have an occupational health doctor or specialist that you use on a regular basis, now is a really good time to be talking to them. If you don't, I know that Fiona and the Chamber are arranging for a webinar in the next week or so with Dr. Shane Farrelly, who is an occupational health specialist and has been working with a range of companies in order to ensure that they're appropriately positioned for reopening. If you follow medical advice, it's very difficult to allege that you've been negligent, and hopefully you'll significantly reduce the risk of employees contracting COVID-19 on their return to work. And then, of course, you have to advertise your own profession, so take appropriate legal advice as and when required. Look after your safety statements, or look at those safety statements. Again, some of you will have produced safety statements way back in the year dot, and they'll be sitting on a shelf somewhere gathering dust, and you won't have looked at them for years. But now's the time to take them down, dust them off, update them, build in a number of provisions in relation to COVID-19 and communicate those safety statements to employees again. All of this will ensure that your chances of defending yourself, if you face claims later in the year or next year, that your chances are significantly improved in terms of defending those claims. And then finally, it's important that we have the necessary personal protective equipment in place. It's been scary to see barbershops and hairdressers in the US opening up again, and everybody's wearing gloves and masks and so on and so forth. And some of the stylists and barbers clearly very concerned about the prospect of contracting COVID-19 or passing it on to their customers. Fiona, if you could take us to the next slide there, that would be great, please. The second question, and this is one that's been cropping up a lot. It was probably actually the most popular question, but a difficult one to deal with first. A number of you have asked about what you might regard as difficult employees sometimes who are reluctant to return to work. So we're preparing to return to work. One employee doesn't want to return. What do we do? Well, I think there's 100 different answers to that question depending on the circumstances. But the first thing that everybody needs to do is talk to the employee in question and find out why. Why are they reluctant to return? got a couple of possible reasons there in the indented bullet points. Some people are saying, well, look, I have COVID-19, so I can't come back, or I'm otherwise sick, I'm sick for another reason. Well, those cases are straightforward. They are people who are on sick leave, and you treat them as if they were out sick in the normal course of events. The second block of explanations or excuses or reasons for not wanting to return is a significant one, and this is arising very often at the moment. So somebody might say, well, look, I have a pre-existing medical condition, and that makes it particularly risky or dangerous for me if I'm exposed to COVID-19, and that's why I don't want to return to work. Now, we can all understand somebody who's in that position. Similarly, they might say, well, look, I have a child who has a particular pre-existing medical condition, or my partner or spouse, or I live with one of my parents who has a significant pre-existing medical condition, and I'm very worried that if I return to work, I'll contract COVID-19. I may not be symptomatic. I'll come home, I'll give it to my loved one, and it could be fatal for them. So that's a second possible reason why they don't want to return. Third possible reason, if they have childcare issues. The schools are closed, they may not be able to find somebody to mind their children, and it's simply that difficulty is preventing them from returning. Or finally, somebody says, well, I'm just generally afraid. Now, they might be a particularly fearful individual, or they may be happy on the €350 a week that they're being paid by the state. Well, what do we do in all of those different situations? Well, here are a few suggestions. The first block is the people who are genuinely sick, the people who have COVID-19 or some other illness. You follow your normal procedures. If your normal procedure in that situation is to say, okay, well, we'll pay you for 5 days, or we'll pay you for 3 days, or we'll pay you for so long as you have a medical certificate, or we'll pay you for 6 months if you're medically certified, you follow that normal procedure. If you don't pay people who are out sick, well, you simply say to them, okay, well, we're all back at work, you're sick, very sorry to hear that, contact social welfare and see what benefits you might be entitled to from them. That's the first situation. Second situation, where they have a pre-existing medical condition, or they have family members in a vulnerable group and they don't want to come back, and you're happy to facilitate them, well, then you allow them leave for that purpose. It may be that you discuss and agree that the employee will take annual leave, although that's probably not the ideal situation right now. You'll probably say to them, look, we'll grant you unpaid leave for a period of weeks, or we'll keep it under review. Let's review it in a fortnight. So for the next 2 weeks, you're on unpaid leave, and you should contact social welfare. For many of those people, the first thing to do is contact their doctor, in fact, and if the doctor tells them to self-isolate, they'll be entitled to the COVID-19 pandemic payment of €350 per week. Third group, those who have childcare issues, well, you might want to talk to them about availing of their parental leave entitlements. And that might be a means of addressing it. Alternatively, you might want to allow them some unpaid leave and review again in the fortnight. With the fourth group, those people who are just afraid to work, about whom you might have suspicions, the people who are happy on the €350 per week, well, my inclination there would be to say, okay, we're not going to force you to come back to work, but the work is there for you. We are going to write to you and invite you back to work. And it's a matter for you to get whatever benefit you manage to get from social welfare thereafter. We're not going to be paying you while work is available. You've been invited back and you've refused to attend. Fiona, the next slide will go into a little more detail on some of that.
Would it be okay if I just jumped in with a question here, Adrian, at this point?
Of course. Yes, absolutely.
Just in terms of unpaid leave, it's not every small business isn't in a position to provide unpaid leave because they need the small number of employees they might have on their team in order to get back to work.
Mm-hmm.
So this puts them in a very difficult situation. That's my first part. How do they deal with that? Certainly
Yes.
in the case of Just Afraid, I'm happy on the 350 per week. And secondly, do you have any idea, or would it be anything that you could inform us as to what that employee might be entitled to in terms of social welfare? Has the government got a scheme for people in those categories?
Okay. If you just take us to the next slide, Fiona, I'll answer those questions in that context. So the small team is a very good question. If you've got 3 or 4 employees and you're going to have difficulty in running the business without one of those, under normal circumstances where somebody is refusing to return to work, if you just look at the second block of bullet points there, 4th, 5th, and 6th, under normal circumstances, you'd be saying to that person, well, if you refuse to attend work when you're required to do so under your contract, we'll have to consider taking disciplinary action against you. And in many instances, that disciplinary action would take the form of dismissal. However, where you do that, you can fully expect that many employees will sue for unfair dismissal and you'll end up before the Workplace Relations Commission. Now, if this was a year ago and somebody was refusing to attend at work, I would say when we get to the Workplace Relations Commission, you will have a very good chance of successfully defending that dismissal, defending that claim. But at present, where we are in extraordinary times, and there are genuine concerns on the part of many people in relation to COVID-19 and illness and pre-existing medical conditions, I don't think the WRC will find in favour of too many employers in that type of case. So I think back off a little if you can, and without meaning to create too much difficulty for you or be offensive to anyone, you're just going to have to suck it up in terms of that small team, Fiona.
Okay.
So in those circumstances, I think, go back to the first set of bullet points at the top of this slide here, write to the employee. My letter out to you, Fiona, in that situation might read, Dear Fiona, I refer to our earlier telephone conversation, in the course of which I explained to you that we're all returning to work on the 5th of May, that work is available for you, that we hope to see you in work on that day. You explained to me that you would prefer not to return to work because you would prefer to continue to avail of the COVID-19 pandemic unemployment payment of €350. It is our belief that you're not entitled to that payment in circumstances where you're not laid off anymore and where work is available for you. But we're not going to take disciplinary action against you for refusing to return to work just at the moment. We'll review in a fortnight's time. You can apply for whatever social welfare payment you might be entitled to, but we won't be informing social welfare or confirming to social welfare or revenue that you're laid off. So you're taking your chances. I started off there almost as if I was dictating that letter to Fiona, so apologies for that. And then later I rambled away a little bit. The bottom line is that individual, if they're claiming the COVID-19 pandemic unemployment payment, is effectively saying to social welfare and to the state, I am laid off. I am entitled to this payment. The reality is they're not laid off because you've told them that work is available, everybody else is returning, and we'd like them to return. So almost certainly they're making a fraudulent claim on social welfare. And I was interested to see a statement issued by social welfare yesterday saying that they will be coming back after people looking for the return of that money later in the year in circumstances where they find that they were not entitled to the payment in question. So that's the risk that those employees are taking. Did that answer the question, Fiona?
Yeah, that's very good. Thanks. I suppose I believe that a large number of our members are some very small businesses, and I hope that that was some use to them. But thanks. Yeah, I fully understand the position now. Not ideal, but we are where we are, and we need to work around it.
Yeah, it's not ideal. And it's simply because we're in such exceptional circumstances. I think it's the answer to this question is going to change on a weekly to fortnightly basis, you know. But at present, that's my view in terms of where we stand. The fourth set of bullet points there on that slide, I talk about trying to offer people, try to offer people choices, okay? So try to be as flexible as you can. If somebody's saying, I have child minding difficulties, well, okay, is there a particular time at which those difficulties arise? Yeah, it's in the mornings. My parents could help in the afternoons, but they're not available in the mornings for whatever reason. Okay, well, here are some options. Option one, you can return to work on a full-time basis as normal because we have the work available. Option two, we'll allow you to return to work temporarily on a part-time basis. So you work in the afternoons when you have childminding facilities available to you, and we'll review in a fortnight. Or option three, avail of parental leave, for example, or it may be that they'll have an entitlement to new parents' leave. So try to offer as many choices as you can, because number one, you're looking after your employees well in those circumstances, and number two, if you run into difficulties with somebody suing you afterwards, at least you're going to look like you were reasonable in your efforts to try to facilitate people. When I said a moment ago, try to offer choices, many of those choices will ultimately end up with the employee having no entitlement to payment. Okay, so if we allow people 2 weeks of unpaid special leave, for example, there's going to be no payment entitlement there. And I think that provides an incentive straight away for people to return to work. One of the members who's attending the seminar today, I won't mention any names, said, okay, but in those circumstances, my employee is going to continue to claim the €350 from the state under the COVID-19 pandemic unemployment scheme. And my answer to that is, yeah, but they're probably claiming it improperly. And if you feel it's appropriate, you can contact social welfare and say, look, we've got all of our people back to work. There shouldn't be anyone claiming that payment from you now. We have work available for everybody. The other thing is, no matter what you agree with the employee, specify a review period. So we'll come back in a week or a fortnight or 3 weeks and review exactly where we stand. That review period is probably best aligned to the extensions that the state is announcing in terms of the lockdown. So as we come into the 5th of May, there'll certainly be some announcement from the government either extending the lockdown for another week or fortnight, or saying we're going to extend it for a fortnight, but we're going to exempt this particular group, or we're going to allow people to move up to 5 kilometres from their homes. But tie your review period into that state review period, I think, would probably be the best thing to do. Fiona, I'll ask you to move to the next slide if you don't mind. And just while you're doing that, I should explain that in relation to that temporary wage subsidy scheme, not the COVID-19 pandemic unemployment payment, the temporary wage subsidy scheme, that scheme allows employers to benefit from effectively a subvention or subsidy of wages from the state. And that applies whether the employees are laid off or on part-time working or reduced working hours or working full-time. So there's a lot of scope for changing your arrangements with your employees under that scheme. And if, for example, at the moment people are on layoff and they're being paid and the employer is benefiting from that subsidy scheme, you can quite reasonably turn to your employees and say, okay, we're going to implement a phased return to work. That phased return to work might involve you coming in for 20 hours a week over the next few weeks. You'll continue to get paid your normal wages and we'll avail of the wage subsidy scheme. But in order to get that, you're now expected to work 20 hours per week. If you refuse to work for 20 hours per week, we won't be paying you. So there's some flexibility there for employers. The third question that has been cropping up quite a bit is whether or not we can require people or force people to return or expect people to return lawfully. Okay. Now this is the flip side of one of the questions that was arising very early in this pandemic. Can we stay open? I think it's important that we don't automatically assume that just because there's some discussion in the media about reopening the economy, that everybody will be able to return to work all in one big rush. At present, the return on the 5th of May is just an assumption that people are making. I can't see a complete relaxation of the existing rules happening on the 5th of May. So the current legal position is regulated by the 2020 Covid-19 regulations, the full name of which, full horrendous mouthful of a name, is set out there at the third bullet point. So the Health Act 1947, Section 31A, Temporary Restrictions, Covid-19 Regulations 2020. They were introduced on the 7th of April. Initially, they applied for just 4 days, but they've been extended to the 5th of May, and I expect to see them extended again. Now, the fourth of those regulations, Regulation 4.1, says that an applicable person shall not leave his or her place of residence without reasonable excuse. So you can't leave home unless you have a reasonable excuse. Now, reasonable excuse is then defined in the regulations, and the regulations effectively provide for the rules with which we're all familiar. You can leave home in order to take your daily exercise as long as you stay within 2 kilometers of home. You can leave home to go and do your shopping as long as you're not traveling excessive distances in order to do so. It's an extraordinary measure because it effectively restricts our liberty. But interestingly, and this is a provision that was put in place to assist the Gardaí in enforcing the lockdown, it's a criminal offence if you leave your home in circumstances where you don't have a reasonable excuse. And that criminal offence can result in imprisonment for a period of up to 6 months, or the imposition of what's known as a Class C fine, a fine of up to €2,500. Now, we're not going to see too many people prosecuted as a result of breach of the regulations, I think, not unless they're extended for a considerable period. But the important thing from our perspective in terms of employment, Fiona, you might take us to the next slide there, please. The important thing in terms of the regulations is that reasonable excuse for leaving home only includes going to work, where you're going to work in an essential service. So anybody else who goes to work is committing a crime. Now, this feeds into the hands of the employee who doesn't want to return to work. Because if I'm working for you and you say, well, we're reopening and we expect you to come back to work, and I can reasonably argue that I'd be committing a criminal offence by going to work, very hard for you to force me back. So we're interested then in knowing, well, who is providing an essential service? And when the lockdown was introduced first, the definition of essential services wasn't immediately available. We were told that within 24 hours they'd produce regulations. When I say they, the government would produce regulations. It actually took more than a week. And the list of essential services that was subsequently produced is very, very lengthy. Now, I'm not going to go through each and every one of them. I've listed a number of them on the screen there. So farming, fishing, manufacturing of certain products, repair and installation of machinery, repair of vehicles or bicycles. It's an interesting set of regulations. It seems to be obsessed with bicycles, as they're mentioned on a regular basis through the regs. If you could take us to the next screen, or the next slide, please, Fiona, you'll see here's more. Here are more categories of people who can go to work. Those who are engaged in providing electricity, gas, water, sewage, construction, but only where construction is related to the development of essential health projects and repair, roads, rail and utility infrastructure, and emergency maintenance and repair to businesses and residences. The next category is wholesale and retail, transport, hotels, but only where they're providing essential accommodation, food and beverage services, information and communications, that includes journalists, newspapers, TV stations, some financial, insurance, accounting and legal services. So for example, with legal, that was the one that was of interest to me, obviously. Initially, they were saying lawyers who were providing support to essential services. Then they published the regulations and said, well, practicing solicitors and barristers are providing essential services. So that doesn't necessarily mean that our support staff are. So there's been a number of different interpretations, I know, taken by solicitors around the county. My interpretation of what the regulations actually say is that while I could, in theory, travel into work if necessary in order to do my job, in fact, I'm working from home because it's not essential that I'm in the office, and I can, in fact, do some of my work from home. The little bit of work that there is to be done in circumstances where the courts are effectively closed. So it's important, if you're looking at returning to work and demanding that your employees, or asking your employees to attend at work, that you ensure that they're not in fact committing a crime by traveling to work. The next slide there, Fiona, lists more of those areas that it's lawful to engage in at present: provision of engineering, scientific and technical activities, renting and leasing vehicles, and here the bicycles back again, administrative and support activities such as payroll, IT support, etc. And there's more listed out there. These are just a summary of what's contained in the regulations. Again, I'll be happy to send anyone a copy of the regulations if they want to see them. You can also download them online. But there are some very precise provisions contained in there. What I expect to see happen on the 5th of May is that if there's any relaxation of the rules, it will be that they'll extend the categories of people who can return to work. So they might open up construction a little more, for example, which is an industry that there was a lot of controversy about early on in the COVID-19 story. But I think it's one in which it may be possible to ensure social distancing a little easier than in others. If there's anyone in the construction industry on the line, and I'm talking through my hat, my sincere apologies. I've had limited experience on building sites over the course of my working life. Fiona, you might take us to the next slide there, please. The fourth question that has come in quite a bit relates to redundancy payments. Can employees demand redundancy payments if we don't bring them back immediately, or if we keep them on layoff for any particular period of time? This one is fairly straightforward to answer. In general, under the existing Redundancy Payments Act, under normal circumstances, if you lay somebody off or you keep them on short time, and by short time I mean you reduce their working hours and they're earning less than 50% of their normal pay, then if you do that to them for 4 weeks or more, they can give you a notice claiming statutory redundancy payment. You then have another 4 weeks. This is the 4 plus 4 plus 13. You have 4 weeks within which you can give a counter notice. And you don't have to pay statutory redundancy if within that 4-week period you can notify them that you're about to bring them back for a period of 13 weeks unbroken normal work. Okay, so that gave rise early on to concerns that if we laid people off during COVID-19, they'd all come looking for redundancy payments, and that could be impossible for some companies to meet, okay, because of the amount of money that would be involved, particularly if you've long-serving employees. Now, the COVID-19 Emergency Measures Act, introduced just a few weeks ago by the government, suspends that normal rule. So nobody who's laid off at present, nobody who's on short-time working at present can come to you and demand statutory redundancy payments right now. The suspension of the normal rules applies from the 13th of March to the end of May, 31st of May, which indicates that back in March, the government were expecting the lockdown to last probably until the end of May. And that suspension of the normal rules can be extended. Some employers might have thought, okay, well, this is the ideal time to make people redundant then. No, that's not the case, okay? Because if you make people redundant, they of course still have their entitlement to statutory redundancy money. All that's happening here is the normal rules that entitle entitle an employee who's laid off to come demanding redundancy, those rules have been suspended. Fiona, you might take us to the next slide there if you don't mind, please. Okay, the fifth and final question that we wanted to answer this morning. Does absence on layoff or the pandemic unemployment payment constitute a break in service? Now, somebody's been thinking very cleverly here, very laterally. So normally, where I commence work with you and I continue to work with you over a period of years, my period of continuous service is continuing to grow. And as it grows, I acquire a range of rights under legislation. After I have a year of continuous service under my belt, then I'm protected under the Unfair Dismissals Act. After I have 2 years of continuous service under my belt, I'm protected under the Redundancy Payments Act. Does the current layoff that applies in many workplaces, does that break that continuity of service? Does that set it back to zero? Does it mean that when people return to work, they won't be protected under those acts? No, that's not the case. This doesn't break continuity of service because we have what's known as a suspension theory. It's the fourth bullet point there. Suspension theory operates in employment law. There are certain circumstances in which the contract of employment is temporarily suspended. People aren't obliged to perform work under the contract. Employers aren't obliged to pay under the contract. The contract is just in stasis, temporary suspension. Normally, that really only arises as a concept where there's a strike going on. I think it's going to apply here. When we return, the courts and the Workplace Relations Commission will say the contract was temporarily suspended, but it was not broken. So looking at the second bullet point, there's only a break in continuous service if the employee has been dismissed or has resigned. And neither of those has happened in the current instance in most places of employment. Some confusion can arise because of a difference between the law and revenue and welfare practice. So I got a bit confused myself, to be perfectly honest, listening to Pascal Donoghue and Leo Varadkar announcing the COVID-19 pandemic unemployment payment and temporary wage subsidy scheme initially, because they talked about maintaining the link between the employer and the employee through the temporary wage subsidy scheme. And they use the word unemployment when they're talking about the pandemic payment, 350. You're not, in fact, unemployed legally if you've been laid off during this crisis. Your contract of employment has simply been suspended, hasn't been terminated, so there's no break in continuity of service. Now, normally when I'm presenting at a seminar or meeting you face-to-face, I can judge by your faces whether or not you're understanding what I'm saying, if it's of interest to you, if you have questions. Obviously, I can't see any of you at the moment. I can see Fiona, but I'm hoping that I haven't put you to sleep there. I'm hoping that most of that made sense. And I'm assuming, based on the lack of questions, that I've explained things relatively clearly. But if I haven't, then obviously I'm more than happy to take any questions that you might have. Fiona, you might just move us on to the next slide there, please.
I think we have some questions, if you'd like to address them there, Adrian, or do you want to do that now, or would you like to move on?
Yeah, I'll certainly do that now. I'm just looking at the chat.
Yeah, that's what I was looking at too. Here we go. So,
Right.
from Morris, do you want to just deal with them yourselves? I'll leave you to it.
Where there's not enough work to bring the whole workforce back, what is the most lawful way to bring staff back? Okay, that's an excellent question. So if let's say you have 4 functions and only one of those functions is going to resume, then normally you would expect that the employees who are associated with that function, who normally engage in that function, will come back. So if I have, for example, an accounts department and the accounts function is allowed or permitted to resume, then I'll bring back the accounts staff. If, however, I'm in manufacturing and I manufacture, let's say, 4 products, but my operatives are all interchangeable. They can all manufacture all 4 products. Who do I bring back in those circumstances? Well, the important thing is that you take an objective approach, not a subjective approach. And what do I mean by that? You take one that's unbiased. You don't say, we'll bring back all of the men because they might need to increase their income to be able to support their families. You don't say, we'll bring back all of the people with blue eyes. You don't say, we'll bring back all of the Polish workers because they tend to be a little bit less demanding. Any of those types of decision are discriminatory and open you up to the possibility of being sued under the Employment Equality Act. But if you decide, for example, that you're going to bring back those staff who have the most experience in dealing with particular machines or a particular product line, then that will be a fair and reasonable approach to dealing with things. I hope that answers the question. The next question I can see is if the employee is under probationary period of 11 months and they're on layoff due to COVID-19, can you extend the probationary period further than the 11 months? Or does the employee now have the rights and entitlement to unfair dismissal if we exceed the 12 months from commencement date? Excellent question. Okay, so I think the first point to make there is that you need to check your employment contract, because the employment contract may well answer that question. Some employment contracts will say that a probationary period of 6 months applies, or that it's 6 months of active employment. There's a difference there. Where you say 6 months of active employment, then they actually have to actually be at work for the 6 months. So if 3 months in, you had to lay them off, then they haven't completed 6 months of active employment. When they resume, the second period of 3 months will commence, and the probation period will continue to apply. However, all of that having been said, the probationary period, while important, is not the be-all and end-all. The be-all and end-all is the Unfair Dismissals Act, because protection kicks in after 12 months of continuous service. Will people be deemed to have 12 months of continuous service if they started on, let's say, the 1st of May 2019 and they returned to work 2nd of May 2020? Have they completed 12 months of continuous service? They'll probably be deemed, in most cases, to have done so, even if they've been laid off for a period. Yes. The next question: do you think that government will change legislation with regard to redundancy in the near future? If we do really need to use redundancy in some cases, there's a strong chance of that, Laura. I know that prior to the regulations being introduced recently, there was a lot of discussion around the cost of redundancy. And you might remember, depending on your age, a number of years back, where you were compelled to make employees redundant, there was a rebate system operated. So where the employer terminated somebody's employment by reason of redundancy and paid a redundancy lump sum to them, they would get a substantial rebate from the government. So effectively, the government picked up the bulk of the tab for redundancies, or at least for statutory redundancy payments. There was talk of that rebate scheme being reintroduced in light of the COVID-19 pandemic. Now, what they chose to do instead was very clever. That was to suspend the entitlement to demand redundancy payment from your employer. But I think when we come back, it's very likely that a lot of people will have to, unfortunately, implement redundancies. And sadly, we will see a lot of jobs being lost across the economy. I think there will be considerable pressure from employers' groups to reintroduce the rebate in those circumstances. And there may be pressure as well to change the entitlement in relation to statutory redundancy. There'll be pressure in the opposite direction, of course, from the trade unions. But I think, yes, there's a significant chance that the legislation in relation to redundancy will change in the near future. I'm not aware of current plans. If you're aware of anything, Laura, I'd be interested to hear about it. So it's definitely something, it's an issue on which we'll have to watch this space and possibly talk about again in a relatively short space of time. Okay, so I hope those answers deal with the questions that people have posed. I can't see any other questions on my screen at the moment.
Hi, Adrian. There is another question there. One, if I'd like, I can read it to you if you can't see it.
Thanks.
In relation to redundancy, if the emergency period is not extended and people are still on layoff or short-term hours, can the weeks during the emergency period be included in the 6 out of 13 weeks?
I'm sorry. Can you give that to me
Sorry,
again?
you
I
can't.
was trying to find it myself here on the screen.
Okay. In relation to redundancy, if the emergency period is not extended and people are still on layoff or short-term hours, and the weeks during the emergency period be included in the 6 out of 13 weeks.
I'm going to say that I'm not quite clear as to exactly what's being asked there, and if the questioner would mind sending me an email, you can see my email on the slide. It's atwomey@jnt.ie. I'll deal with that question directly with you. It'll take 2 minutes, but I just want to ask you a couple of ancillary questions before I can address that properly. So,
okay, I have another question for you, please.
Yeah.
I have a comment from Laura, who you spoke to a moment ago. She said, "Thank you. I remember, unfortunately, it is in situations where salaries are just high to carry on under circumstances." I assume that's in relation to the redundancy payments. You mentioned there when you said you remember where the redundancy regulations were different, where people paid, where there was a clawback.
Yes, Laura does remember the rebates being paid. Okay.
And there's a question here from another person. Can an employee claim the reduced working hours from social welfare up to 3 days and the employer use the wage subsidy scheme also? So can an employee claim the reduced working hours from social welfare and the employer use the wage subsidy scheme at the same time? Will there be two claims?
Yeah, I suspect in many circumstances that wouldn't be lawful or appropriate, but it'll depend on the precise amounts being received by the employee. But if an employer is using the wage subsidy scheme and is paying the employee at least 70% of their normal wages, then I don't think the employee would be entitled to that reduced working hours payment from social welfare. They might be claiming it at present and they might be receiving it, but I don't think they're entitled to it. And I suspect they might find that social welfare come back to them afterwards looking for repayment.
Okay, Adrian, that's the end of the written questions here. I would like to thank you on behalf of County Wexford and on behalf of business owners and managers. I think you answered some very important questions there and gave us lots to think about in terms of nuances that perhaps we wouldn't have ordinarily considered.
I'm
I know
sorry,
you,
Fiona, I've just spotted some more questions in the Q&A heading there. I understand and appreciate that many people will need to leave the webinar at this stage, but if it's okay, I might just very quickly attack those questions.
of course.
Glenda 2015 says, if you have an employee who doesn't wish to return to work and you have to hire someone new to the job, what happens when they do wish to return? Well, I think that, again, in terms of my comments earlier, the first thing is to establish why they don't want to come back. Try to facilitate them insofar as you can in the short term. Hopefully you won't need to hire somebody immediately. If you do need to hire somebody immediately, then you try to hire them on a temporary basis. So if you're saying to your existing employee, well, look, I'll allow you to take another month off, unpaid. During that 1 month, I'm going to need to bring somebody in on a temporary basis to do the job. You hire somebody on a 1 month basis or on a fixed term contract. And then at the end of the month, hopefully your permanent employee will return. If they continue to refuse to return, then you may at some point arrive at a stage where you're having to say to them, look, at this stage, it's return or leave. But hopefully you won't arrive at that point. Second question that I can see here, hopefully Glenn, that answered your question. If it didn't, please feel free to come back at me on it. Anonymous attendee, holidays. What's going to happen with employees' holidays, as no one wants to take holidays now, but when we're back in work later in the year, employees will want to take them and we might need them to work. Okay, so the normal holiday rules will apply, and it's a good question, and it actually prompts me to address a point that I had hoped to address earlier on. So under the Working Time legislation, the Organisation of Working Time Act, the employee is entitled to either 4 working weeks off paid during the year, or 1/3 of a working week for each month in the leave year in which they work 117 hours, or 8% of the hours that they actually work, subject to a maximum of 4 weeks. There's 3 alternatives. And at present, because people are not working very often, the question arises, well, is that going to result in them having an entitlement to fewer holidays later in the year? And I think in most cases it probably won't, because you're entitled to 4 working weeks leave if you work at least 1,365 hours in the year. And when you average that out, that's less than 30 hours a week. Now, if people are laid off for a month, they'll still work more than an average of 30 hours a week when you take that across the entire year. So I think for most people, they'll still have their full leave entitlement. Anonymous is saying, well, no one wants to take their holidays now, but when we're back in work later in the year, they'll want to take them and we might need them to work. Well, the normal rules will apply there. You can say to employees, look, I can't facilitate you in terms of holidays right now, but I can facilitate you at this later date. So normally you expect employers and employees to try to agree on the dates to be taken. The employee cannot insist on particular dates if business needs can't enable holidays to be taken at that point in time. As an employer, responsibility is to ensure that your employees get to take their leave, but ultimately if there's a dispute, you get to decide when they take that leave, subject to being reasonable in terms of allowing them appropriate time off. It's not reasonable, for example, to say to an employee, you can't take any holidays during the summer under normal circumstances. You must take all of your annual leave in November. That's not normally reasonable. This year, I think employers will get a bit more latitude. The next question is from Finance. Can an employee can an employee claim the reduced working hours up to 3 days and the employer use the wage subsidy scheme? Well, I think we've addressed that question. It was pushed in the chat window. Next one is from Anonymous again. Can an employee claim, sorry, we've dealt with that, apologies. Okay. I think that's all the questions I can see, Fiona. Sorry for cutting across you there. I just didn't want to leave without answering all of the questions that people were putting to us. Fiona, you're on mute at the moment, I think.
Right, I'm sorry. We do have a couple of other questions. Do casual and full-time staff accrue holidays while on layoff?
Normally, you only accrue holidays where you're working. So if you're laid off, you're not accruing holidays.
Okay. Is a layoff considered as reckonable service when calculating redundancy?
Generally, no.
And after that, we have some nice comments. Thank you, guys. People are complimenting you. Adrian, great webinar, Adrian. Thanks for the information. Great webinar, very informative. Thank you. Very good seminar. Thank you. That was excellent. Thank you. So I'd like to echo that. There's lots of thank yous coming in, Adrian. And on behalf of the County Wexford Chamber, thank you for your time. Thank you for going over the hour. Thank you to the 50+ people who joined us this morning. The slides will be made available to anybody if you want to contact Katie O'Connor at wexfordchamber.ie, and we'll be happy. There's also going to be a recording of this, so hopefully the quality will be good, and you can ask Katie for that also. We have got some other excellent follow-ups to this coming up. Particularly, Adrian mentioned Dr. Shane Farrelly, an occupational health expert, who is going to give us some advice about getting back to work. And we will also have some other very exciting ones about how to trade post COVID-19. I would hate to let this opportunity go without asking everybody online to please respond to our very important survey, revivingwexford.ie. It will help us to provide an action plan for the post-COVID recovery in Wexford, and your say is very important. So on that, Adrian, thank you. Guests, thank you, and we'll talk to you all soon. Slán.